Let's move to contract law. Under contract law, there's bilateral contracts and unilateral contracts. A bilateral contract is a contract where there's promises made for a promise. The best example would be a real estate purchase contract or perhaps a promissory note. Unilateral contracts, a great example would be a promise only going one way, would be an employee who is an independent contractor actually works for a broker. The broker contractual agreement would be a unilateral contract. Another good example of a unilateral contract would be an option agreement. At the time an option is entered into, only one person is making a promise, and that would be the seller. What happens is if an optionee, a buyer, decides to exercise the option, at that point in time it becomes a bilateral contract. But initially it's only unilateral because the buyer doesn't have to buy, but the seller, of course, must sell. There's 4 essential elements to a contract, and there's a kind of a quasi-fifth one because of the Statute of Frauds. Let's talk about the first 4. Mutual agreement is an essential element of a contract. There must be a meeting of the minds. A favorite question on this one might be a mistake, where a buyer buys a property, let's say it's a lot, and they think they're buying lot 7, but really they're standing on lot 9. Well, they could even close this particular agreement, and they really don't have mutual agreement because there was a mistake made. In this case, the contract from the beginning was void because there was no element of mutual agreement. Consideration is also an essential element of a contract. Consideration, a good example of this would be a Rep C contract where a buyer enters into an agreement to buy a home from a seller. At that point in time, the contract was valid. But then the house burns down before the closing occurs. Can the seller give the same amount of consideration he originally contracted for? And the answer obviously is no. It went up in smoke. So that contract that was valid has become voidable. Another one is capacity, the essential element of capacity. On capacity, the favorite question on this is an adult and a minor. If an adult and a minor enter into a contract, that contract from the beginning is voidable because the adult does have capacity, but the minor lacks it. So the minor, the disadvantaged party, could decide to cancel that contract at any time. But should the minor decide to complete the contract, the adult would be bound. Legal purpose, if a law changes in a jurisdiction, making the use of the property illegal, and that use was stated in the lease or perhaps the purchase agreement, then you would have a valid contract that then became voidable because the law changed. Statute of Frauds is a law that kind of adds that 5th element to the essential elements of a contract. But the Statute of Frauds really only addresses one issue, and that is the contract enforceable in a court of law or not? So it's not truly an essential element of a contract because you can have a verbal contract that is valid, but in most instances it would be unenforceable, certainly if it was for the purchase of real estate. But there are some verbal contracts that are enforceable in a court of law if it's for $500 or less of personal property, or if it's for a contract that can be performed within 1 year of the day of making the contract, that can also be enforced in a court of law. For example, the Statute of Frauds says any contract that takes longer than a year to perform must be in writing. So a 1-year verbal lease could be enforced in a court of law. But I'd pity the poor fool, being the landlord, who went up in front of a judge where everyone's just trying to remember what the contract said. It would be a real problem. Let's talk about different ways to terminate a contract. The very best way would be performance of the terms of the agreement. The buyer buys, the seller sells, everybody gets their commissions, everybody's happy. But contracts can also be ended by mutual agreement. It's called a rescission. A rescission is a contract to end a contract. Sometimes contracts are assigned, as we mentioned earlier. And most contracts can be assigned unless they are prohibited, like in the rental agreement I mentioned earlier, or perhaps it calls for a personal performance on behalf of one of the parties, like, for example, a listing agreement. Listing agreements cannot be assigned. They can only be canceled, and then it can be relisted by another broker. But all other contracts, unless it's prohibited or calls for that personal performance, may be assigned, which takes one of the parties out of the contract. Novation is where this party is taken out of the contract and receives a release of liability. And then sometimes contracts just become impossible to perform. Something happened which changed the law or changed the nature of the properties being sold. Therefore, it's impossible to perform, and therefore that contract can actually be canceled as well.